Hey, my dear friends and fellow justice seekers. Thank you for joining us. Have you ever faced a situation where hiring a lawyer was out of reach, and yet justice was calling your name? Today, we'll explore whether representing yourself, being your own advocate, is truly possible in civil courts. Before we dive in, a quick note. This episode is for informational purposes only and not legal advice. Always consult a professional for specific guidance. First, let's clarify what pro se means. Pro se is a Latin term meaning, for oneself, it's when you represent yourself in legal proceedings without a licensed attorney. Our judicial system might seem impossible, but it's not unbeatable. It's a war fought with words on paper. In court, it's like a chess game where every move is planned and executed with strategy, and the rules are as important as the moves. Remember, not all licensed attorneys are proficient in legal writing. They must practice, practice, and practice. And so must you if you decide to represent yourself. This is an important and difficult topic that tackles the critical access to justice issue. To many self-representing pro se litigants, it is an emotional and personal journey that is filled with unknown and significant challenges. However, it's not accurate to say that the pro se litigants can never win. Let's start with a fundamental truth. You have a constitutional right to represent yourself. The landmark U.S. Supreme Court case Farada v. California, 422 U.S. 806, 1975, affirmed this right. While Farada is a criminal case, its principles echo across the entire legal system, emphasizing the right of every individual to stand up for themselves. The key points of the Farada decision is that it affirmed the Sixth Amendment right of a criminal defendant to self-representation and established that defendants can waive their right to counsel, and that courts must respect a defendant's knowledge and intelligent choice to represent themselves. Justice Byron White, writing for the majority, emphasized that the right to self-representation is fundamental to the adversarial system and individual autonomy in criminal proceedings. This case is considered the definitive authority on a defendant's right to self-representation in criminal trials and has been widely cited in subsequent legal proceedings. Let's break down the real challenges pro se litigants face in civil matters, and more importantly, how to overcome them. There are some uphill battles as to understanding the challenges. Even licensed attorneys face the same challenges. 1. The knowledge gap. Here's the brutal truth. The legal system speaks a language all its own. It's like trying to navigate a foreign country without a map or translator. Legal procedures, court rules, evidence standards. These aren't just hurdles, they're entire obstacle courses. Imagine trying to solve a puzzle without knowing what the final picture looks like. That's the legal system for pro se litigants. Here may be some steps to understand it better. As lawsuit goes forward and further develops, the legal knowledge may become barriers for pro se litigants. For example, complex legal arguments, objections to improper evidence, effectively cross-examine witnesses, etc. Not to mention the personal emotional investment and attachment to the case. There is also the risk of potential for argumentative or inflammatory statements. 2. Procedural landmines. Courts have zero patience for procedural errors. Miss a deadline? Your case could be dismissed. File that motion the wrong way? It's going straight to the rejected pile. Ouch! It's all about being precise. 3. The invisible bias. Let's talk about something nobody wants to discuss: judicial perception. Some judges may unconsciously view pro se litigants as less credible. It's like walking into a job interview without a suit. You're fighting an uphill battle before you even speak. Now, let's turning the tide. Strategies for success. 1. Preparation is your superpower. Here's your battle plan. Research, research, and more research. Understand court rules like they're your personal Bible. Practice your arguments. Stay calm and professional. 2. Utilize free resources. You are not alone. Many courts offer self-help centers, online resources, pro bono consultation services, free legal clinics. 3. Emotional intelligence matters. The most successful self-represented pro se litigants aren't always the most knowledgeable, they're the most composed. Leave emotion at the door. Be clear, concise, and professional. Well, success is possible. If we do a little digging, there are some statistics about cases where individuals won without legal counsel. You are not just representing yourself. You are also representing the idea that justice matters and is for everyone. Let's prove that together. So, listen up. Pro se litigants do win cases. Not always, not easily, but it happens. Your determination, preparation, and strategic approach can absolutely make a difference. Just like not every licensed attorney wins every case, but loses too. Remember, the legal system isn't designed to be easy, but it is designed to be fair. You have rights. You have a voice. And with the right preparation, you can absolutely be heard. Just remember that all the licensed attorneys will have to do the same hard work, the same legal procedures, the same legal research, the same court requirements. It also takes licensed attorneys years to be familiar with the court rules and procedures, and they still have to keep themselves current at all time. And so can you. Stay informed. Stay prepared. Stay powerful. In our next episode, we will discuss curt filings such as motions and briefs and explore some of the potential biases in our judicial system. Don't forget to like, subscribe, and share your self-representing pro se journey in the comments. Thank you so much for watching. Again, here's the disclaimer. This video provides information and is not legal advice. Each legal situation is unique, and viewers should consult appropriate legal resources or professionals for specific guidance.